Hello, everyone. I'm Julianne Story, a partner in Husch Blackwell's Labor and Employment Group in Kansas City. And I'm here in Kansas City a little over 6 feet from my colleague, AJ Weisler, a partner based out of St. Louis. We are so excited to be the host for today's National Labor and Employment Virtual Program.
Hello, everyone. And after today's national program, our Labor and Employment Group will be putting on 5 regional programs in for each of our offices over the next 5 weeks. So please be sure to join us not only for today, for any of those regional presentations that might interest you. And I have not actually gotten official approval from the firm for this, but I'm going to go out on a limb and say that anyone who attends all 6 presentations, that's today and the next 5, will be entitled to receive a heartfelt congratulatory remark from any Husch Blackwell attorney of their choosing.
What a great prize. Before we begin, we would like to cover a few housekeeping items. On your screen, there are multiple boxes and icons for your use during the program today. We would like to take a minute to highlight a few of the key items for you. First, if you're having any technical difficulty, please refer to the audience technical tips on your screen or click on the help icon at the bottom of the screen. It has a question mark and provides information regarding common technical issues.
If you happen to be viewing this program from a mobile device, be sure to be using the Chrome browser, and we recommend turning your phone or tablet into landscape for optimal viewing. When the screen is landscape, you can click on the box in the lower right corner to change the layout.
If you have any questions during the program, please submit them via the question box. We'll try to answer all of the questions during the program today. But if a fuller answer is needed, or if we run out of time, it'll be answered later via email. We truly appreciate audience participation and encourage you to submit your questions.
A copy of the presentations, speaker biographies, and links to connect with us on social media are available in the resource folder.
This program has been approved for HR and legal continuing education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing.
And you're going to want to share it. And toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your specific needs.
We have 3 sections of content today, each about 20 to 35 minutes in length, and we'll have a short break between each section in case you need to step away for a few minutes. But fair warning, we plan to sneak in some fun into the breaks, and you may want to stay at your computer.
Joining us today as presenters are Husch Blackwell partners from across the country. To kick off our program, we will have attorneys sharing some legal updates on new legislative issues, regulatory and statutory changes, and recent U.S. Supreme Court decisions that affect your workplaces. After that, we'll have another group of attorneys discussing a variety of hypotheticals addressing the continuing impact of the pandemic on employers.
Finally, we'll talk about some other hot topics that our employers are facing this fall, including election leave, the movement for social justice within the workplace, NLRB updates, and work from home issues in our new reality. So now we'll send it to our first group of presenters, Barb Grandjean, Joe Glinius, Tom Godar, and Ben McMillan. Tom, take it away.
Good morning, and thank you so much, AJ and Julianne, for introducing this pretty timely presentation. And the first step that we're going to take is provide a legal update on certain legislative, regulatory, and Supreme Court decisions. I'm going to be joined by my partners in this, Barbara Grandjean, Joe Glinius, and Ben McMillan. And the first thing we're going to talk about are the Supreme Court decisions, which frankly, when they interpret and help us apply the law, are usually important to employers, to HR experts, and to those of you who are joining us. And this has been a big year for religious liberty cases. And so the first step that we're going to take is have my partner Ben talk a little bit about those cases from the Supreme Court that are going to help us understand our obligations as HR experts and employers.
Well, thank you, Tom. And I'd like to start by just thanking each and every one of you for taking the time out of your busy schedules to spend this time with us here today. We're always delighted at the opportunity to share with you what's going on in our line of work. I'm going to be talking with you today about 3 recent Supreme Court decisions, all of which dealt with religious liberty. As a very quick and basic review, in the United States, our religious liberties really are found in 3 primary sources. The first is the First Amendment, that's constitutional, protecting citizens from government. The second would be statutory. Title VII protects employees from discrimination based on religion by their employers. And the third is the Religious Freedom Restoration Act, or RFRA. That's also statutory and provides companies and entities with the ability to abstain from doing something or doing something on the basis of their religious objections. The challenge for the Supreme Court in these cases is really to navigate the tension between these different statutes, the liberties created by them, and then also rights created by other statutes. First case I want to talk to you about dealt with school choice. So our higher ed clients will want to pay attention to this one. This was Espinoza versus the Montana Department of Revenue, decided on June 30th, 2020. This was a 5-4 decision dealing with the Montana Constitution's no aid provision. So really the question was, in a situation like this where low-income individuals can apply for tuition assistance paid for by the government to be paid toward their child's private education, can a state prohibit the application of those taxpayer funds towards a citizen's private religious education? The court held 5-4 that indeed that state constitutional provision violated the free exercise clause. So essentially it established a uniform standard for how to interpret these no aid provisions, and in effect now outlaws state laws that prohibit individuals from using taxpayer funds to go toward private religious education. The second case I wanted to talk to you about deals with the Affordable Care Act, or more commonly known as Obamacare. This was decided on July the 8th, 2020. The name of this case is Little Sisters of the Poor versus Pennsylvania. Now, this case followed a famous case, the Hobby Lobby decision, and dealt with an exemption employers can apply for based on religious or moral objections to providing contraceptive coverage to their employees in mandated health insurance plans. This decision, which was 7-2, basically affirmed and expanded that decision, finding that the federal government did indeed have the authority through the specific agencies to allow for an exemption by companies that they can apply for on the basis of their religion or their religious beliefs, that they will not be compelled to provide contraceptive coverage in their mandatory employee health insurance plans. The holding also dealt with essentially removing administrative hurdles to seeking that exemption and just really firms up that holding in Hobby Lobby and makes it easier for companies to say, we're not going to provide contraceptive coverage to our employees on the basis of our religious beliefs. The third and final case I want to talk to you about is Lady of Guadalupe School versus Morrissey Barrow. This was also decided on July the 8th, 2020. This case dealt with the ministerial exception to employment discrimination laws. The purpose of the ministerial exception is to essentially exempt religious employers from employment discrimination laws if the employee bringing the claim of discrimination serves some type of religious function within the organization. This was a 7-2 decision, and basically this expanded the ministerial exception to the employment discrimination laws. It enlarged the category of employees that would be included in that exception. In this case, the plaintiffs were 2 Catholic school elementary teachers. The court said that given the very nature of the religious education, that these 2 individuals were working in a ministerial capacity, that they were serving and did indeed have vital religious responsibilities within the purpose of that organization. So the decision said that such claims cannot be adjudicated by civil courts against religious institutions, and also provided significant deference to the religious institutions to decide for themselves who will indeed serve these vital religious responsibilities and whether they will be categorized as ministers for the purpose of this exemption. I believe that's all the time that I have. I want to thank each and every one of you for lending me your ear, and I'm going to turn it back to Tom.
Good morning, and thank you, Ben, for that presentation. More to come on religious liberties, and in fact, under the case that's on your screen now, the Altitude Express versus Zarda and its companion cases, the Bostic case, and in fact, there's an Arnie Stevens case related. That issue will probably arise, but this is perhaps the most important decision of the court, decided about 2-3 months ago in June, holding that Title VII prohibits discrimination because of sexual orientation or gender identity. While a split decision, 6-3, it certainly cleared the way for Title VII to be applied to provide protection for LGBTQ employees. Obviously, employers are going to have to look carefully not only at this protection, especially if you're in states where this had not been applied under state law, but they're also going to be looking, you're going to be looking at policies related to, for instance, bathroom or locker room usage. You might be looking at your own health plans and seeing whether or not you cover the cost of gender reassignment surgery. And of course, you're going to have to maintain, as we presume you have as clients and friends of Husch Blackwell, a harassment-free atmosphere for LGBTQ employees. This will continue to play out in the future, but certainly this clarified the application of Title VII to the LGBT community. The next case has limited application, but it's a good reminder case. In April, the Supreme Court decided in an 8-1 decision in Babb versus Wilkie that the Age Discrimination and Employment Act, the ADEA, applied a standard that was merely for federal employees to show that age was a related factor rather than a but-for factor for determining whether a case could proceed. When you have a but-for factor, you have to show that that's without the age of an individual, the employment action could not have happened. If you merely determine that it has to be associated with the decision, then many cases will proceed through summary judgment to a time when the employee can prove up that age was a motivating factor. In this case, it's important to realize that compensatory damages may still need the but-for standard to be applied. In other words, if you're going to be fired anyhow, and age did sneak in and participate in the decision, but you were going to lose your job, then you may not be eligible for damages. That's the standard, by the way, that we apply in Title VII. So the lessons from the Babb versus Wilkie case continues to apply to a much broader spectrum than just federal employees. Interestingly, this but-for standard also was important in another decision. This was a 9-0 decision by the court made in March of this year. In Comcast Corporation versus National Association of African American Owned Media, the plaintiff, the National Association of African Owned Media, claimed that Comcast Corporation did not take its programming on its feed because of race. And the court said, well, there might have been a number of reasons which Comcast Corporation set forth. You're going to have to show that race and race discrimination was the but-for cause of the injury that you've alleged, the failure to put your programming on. In some ways, for employers, this will not be a huge change because most of your employees will then proceed under Title VII, if you're a larger employer or a smaller employee under state law. But this is still important for those of us who are involved in litigation because 42 U.S.C. 1981, a Civil War era statute, was often used to beef up a case and had different opportunities for instance, damages. We'll see less of that under this standard, I believe. Finally, a case that's not directly related to employees in the sense of an employment labor case, but will affect you is the DACA case. That is Department of Homeland Security versus Regents of the University of California. In that case, the court in a split decision, 5-4, upheld, at least for the moment, the Obama era policies that provided for Dreamers to go to school, to receive benefits, and to be employees of yours. And I'm sure many of you have Dreamer employees, in spite of the fact that a related law, the DAPA law that affected parents of U.S. citizens and legal residents was found to violate the Immigration and Nationality Act. There's an argument that so does the DACA Act, but the court never got to the legality of the Obama-era policies, but merely said that failure to look at legitimate reliance by the Dreamers on the DACA memorandum or forbearance of removal from this nation was arbitrary and capricious under the Administrative Procedure Act. And so far, the case has said that the Dreamers are still protected under the Obama-era policies. So that's a quick tour through our Supreme Court decisions over the past year or so. And I'm looking forward, though, to Joe Glinius giving us an update on an area that's seen a lot of change and maturation on the wage and hour area. Joe, take it away.
Thank you, Tom. I'm Joe Glinius, and I'm here to discuss some national wage and hour trends. Obviously, coronavirus has really driven a lot of the wage and hour activity this year. We'll be discussing that separately and later on in the presentation. So I'm going to discuss some other trends that'll be relevant to our private employers, although they're fairly little known. The first is the fluctuating workweek. This is a method of compensating non-exempt employees by paying them a fixed salary each week, regardless of hours worked. And plus, the overtime is paid at just half time as opposed to time and a half, which is the typical overtime premium. So the key here is, instead of just paying an employee a certain dollar amount per hour and then paying them for all those hours, each week you pay them the exact same salary, regardless of the number of hours worked. If they work more than 40, you would pay them an additional half time as opposed to time and a half. And the theory there and why this is allowable is for two reasons. One, the Department of Labor assumes you've already paid the straight time for those hours worked. And two, because there will be certain weeks where you're overpaying these employees. They maybe don't work 40 hours in 1 week and your salary would approximate 40 hours of work, and they would only work 35. Because they're being overpaid in those weeks, the Department of Labor is comfortable with the lesser overtime premium for the weeks where they work more than 40. So from an employer's perspective, why do we care? Well, you have the opportunity to reduce your labor costs. And if that's the case, why would employees ever be interested in this, or why would the Department of Labor allow it? Well, a couple of reasons. Number one, because the employee will receive at least the same amount of money every week. There's stability in that for the non-exempt employee, which can help to plan for monthly expenses. So there's a benefit there. The requirements traditionally that you pay this fixed weekly salary, so the same amount. It's got to be large enough to ensure that you're never paying them below the minimum wage. So if they worked as many as 60 hours, you're still covering more than minimum wage for every hour worked. You've got to have a clear and mutual understanding with the employee that this is how they're going to get paid. This doesn't have to be in writing, although we would strongly recommend it. And then your weekly hours must actually fluctuate. Well, this has been a big year for the fluctuating work week. The Department of Labor issued a final rule authorizing additional payments on top of the salary, traditionally, that had disqualified or invalidated the fluctuating work week agreement. The Second Circuit, which is one of the largest federal courts of appeal in the country, ruled that occasional errors in the way that you're paying salary doesn't invalidate the salary basis. And then recently, the Department of Labor issued a letter saying that the hours need not actually fluctuate above and below 40, or even that they fluctuate every week, but there has to be some fluctuation, whether that's 32 to 37 or 42 to 45, whatever it is. It's got to vary from week to week. So what should you do? Well, the trend is clearly supportive of this method, which is good, but that can change. If there were to be a new administration, then you'd have to reconsider whether the Department of Labor changed its position again. Do you have non-exempt employees who work fluctuating hours? Are you comfortable paying a fixed salary as opposed to paying for hours actually worked? You have to consider the limitations. With the salary level, there are certain deductions that are not permissible. And some states prohibit the use of this method altogether. So long story short, this could be a very useful tool for you, but there are many considerations to bring into the analysis. The next trend is the retail or service establishment exemption. Traditionally, this is an exemption from overtime for employees who are paid mostly on commission. Now, employers have usually thought about this as the traditional retail concept, like selling clothes at the Gap. The concept isn't quite so narrow, and I'll discuss here in a moment how that's really been amplified recently. But this is a big thing because employers can avoid their overtime obligation. And that's useful for lots of reasons. The traditional requirements are that you work at a retail or service establishment. And instead of thinking about someone selling clothes at the Gap, think about this as just anyone who provides goods and services at the end of the retail stream of distribution, as opposed to selling to another entity that would then sell to the consumer. You got to pay a regular rate that exceeds time and a half the federal minimum wage, and the earnings have to be coming from more than 50% commissions. It's been a busy year for the Department of Labor. They eliminated an outdated list. About 60 years ago, they implemented a list of approved industries and disapproved industries. That's gone, and that's good because it's allowed more industries to consider the exemption. The best example is that recently the Department of Labor issued an opinion letter saying that workers who drive trucks for an oil field waste removal company are actually involved in retail services. This is based in part on a recent change from the Department of Labor that more loosely construes exemptions. So what should you do? Consider if your business is retail, can you practically pay on commission, and would you pay enough to exceed 1.5 times the minimum wage? Those are the national wage and hour trends, and I'll turn it over to Barb Grandjean to discuss some regulatory and administrative issues.
Thanks, Joe, and greetings from sunny Denver. I'm going to conclude the first portion of today's seminar by briefly discussing regulatory and administrative guidance issues that may be of interest to you all at the national level. First, I want to touch on guidance that's going away. Effective September 27th of this year, the Department of Labor is moving its guidance in documents into a publicly searchable database. During the course of this project, the Department of Labor says it's rescinded nearly 3,200 documents. Once the database is up and running, if the guidance isn't in there, it no longer exists. This is all in response to the Trump administration's push to get agencies to focus on more transparent rulemaking rather than on non-binding guidance documents. My second update relates to the FMLA. The Department of Labor has issued a request for information generally about the effectiveness of the current FMLA regulations. If you've spent much time at all with those regulations, you would probably agree that they are overly complex and they're not easy to implement in the real world. I'm specifically referring to unscheduled intermittent leave, which I know is a huge problem for many of my clients. Comments are being accepted through September 15th, and last time I checked, there were fewer than 75 comments that had been submitted. We'll be watching this to see if it results in some cleanup or some clarifications of the FMLA regulations. Third, and hot off the presses, I want to talk about revised regulations related to the Families First Coronavirus Response Act. On Friday, September the 11th, the Department of Labor announced that it's going to be releasing revised regulations under the FFCRA. These revised regulations will be published and become effective on September the 16th. And the impetus for these revisions was the August 3rd decision by the United States District Court of the Southern District of New York that struck down portions of the original regulations. We wrote about that court decision in the legal alert that we published on August 12th, and there's a link to that on this slide if you'd like to refresh your recollections. In the revised regulations, the court either changed the regulation or elaborated on the reasons why the original regulation is in fact valid. As to the work availability issue, the but-for test still stands. An employee is only eligible for paid leave if, but for their COVID-related issue, there would be work available for them to do. The definition of healthcare provider from the original regulations has changed significantly. The court pointed out in its decision that as drafted in the original regulations, a librarian working at a university that has a hospital could be exempted from coverage under the FFCRA. The Department of Labor has revised that regulation and to make it clear now that only physicians and others who make medical diagnoses and other employees who are employed to provide diagnostic services, preventative services, treatment services, or other services that are integrated with and necessary for the provision of patient care are considered to be healthcare providers who can be excluded from coverage under the FFCRA. As to the intermittent leave issue, the Department of Labor reaffirmed its position that intermittent paid leave under the FFCRA can be taken, but it has to be agreed to by the employer. And then on the documentation issue, the Department of Labor has clarified the regulations to say that the documentation needed for leave has to be provided only as soon as practicable and not necessarily before the leave is taken. So to me, one of the biggest unknowns for employers now that these revised regulations are coming out is for the employers who have or have not provided paid sick leave up until now, primarily in the healthcare provider area, and whether they're going to have to go back and essentially do an audit and perhaps go back and pay sick leave for people they had previously excluded from coverage under the very broad definition of healthcare provider. So you can rest assured that we will be publishing a legal alert on these revised regulations. I don't have time to cover them in any more detail today. Then finally, I want to talk about another court decision that happened in August that may also result in changes to the regulations. And that has to do with the Department of Labor's rule regarding joint employer status. This was the same court, but a different judge, and the rule has been vacated as to vertical employment relationships, and that would be something like a general contractor and a subcontractor. So at this point, we don't know if we're going to see revised regulations or if the Department of Labor may appeal the court decision. You should look out for a legal alert from us on this topic as well. And with that, back to AJ and Julianne.
Thank you, Barb. Everyone, we are so happy to have over 700 attendees on the webinar today, and we ask for your patience while we try to fix the delay between speakers. We are going to take our first break of the day, which will last about 5 minutes, so please feel free to step away if you'd like.
But for those of you who stick around, Julianne and I plan to share a little bit of hopefully useful information about some of the behind-the-scenes strategizing that goes into preparing for a national seminar like the one we're putting on today.
Preparing to address a national audience presents a number of significant logistical and technical considerations, but we wanted to discuss with you a particularly difficult challenge and our solution for it. Before we dive into the biggest challenge of our national program, this is a good chance to remind you all that after today's presentation, we will have a series of weekly local seminars that will be presented live on each of the next 5 Tuesdays and available on demand afterwards.
And our first local presentation will be put on by our colleagues in Denver addressing Colorado law. And that will be next Tuesday, September 22nd, which also happens to be my birthday. Of course, if you're anything like my mother, you're probably more excited about my sister's birthday, which is coming up on September 21st.
Oh, that's right. Be sure to tell Greta I say happy birthday. And the rest of you can find the link to register for any or all of the local presentations at the bottom of your screen.
And that brings us to the biggest challenge of presenting a national seminar. And that was figuring out how to pander to a national audience. Because we have pandering to our local audiences down to a science.
That's right, AJ. I know in Kansas City, all we have to do is talk about how our barbecue is better than everyone else's.
And our attorneys in Denver love to talk about that statue called Big Blue Bear and discuss how accurately named it is.
And in Milwaukee, our attorneys can always slip in references to beer, like the one that made Milwaukee famous, Schlitz.
And our colleagues in Texas love to craft employment law hypotheticals starring Chip and Joanna Gaines and their silos in Waco.
And Chicagoans love it when we talk about their sports teams like their beloved Cubbies.
And in St. Louis, we can also score some easy points with our audience by talking about the Chicago Cubs. Despite our expertise in being able to pander to local audiences, at first, we were flummoxed about how to engage with an audience that spans the country with completely different viewpoints and experiences. But then we stumbled into what we think is a pretty innovative way to tailor our presentation to every single one of our hundreds of audience members today.
That's right. We are tapping into everyone's favorite fill-in-the-blank word game of yesteryear, Mad Libs. So this is your chance to star in the webinar presentation to create a webinar experience that is perfect for you.
So grab a pencil and some paper or crank up your memory, because we'd like you to storm your brains for some ideas. And another benefit to this activity is that studies have shown us that individuals who are actively engaged in a webinar are 50% less likely to be asleep at the same time. So,
first, think of a local sports team like the Kansas City Chiefs or your nephew's T-ball squad.
Next, think of a living celebrity that your locality claims. For example, I grew up in Springfield, Missouri, and we claim Brad Pitt because he grew up there, and Bob Barker because I think he went to school there, and a third international heartthrob that is doing this presentation today.
Then think of a local grocery store chain like Piggly Wiggly or Hen House or Food Lion.
Next, think of a local landmark like the Paul Bunyan statue in Portland, Oregon, or the Paul Bunyan statue in Bangor, Maine, or the Paul Bunyan statue in Klamath, California, or Cheshire, Connecticut, or Akeley, Bemidji, or Brainerd, Minnesota, or any of a dozen other cities across America.
Next, think of your favorite local food. And here's another opportunity for me to mention Kansas City barbecue.
And now that you have your list ready, it's time for us to engage in some very targeted, very specific, individualized pandering. So please take it away, Julianne.
We'd like to thank each of you again for joining us for our video webinar today. And how about those?
Insert local sports team.
Boy, howdy, how about that team? And they sure are good at competing in that sport in which they are famous for competing. And I'd like to echo Julianne in thanking you for joining us for our event today. I am as excited today as I was the day that I caught a glimpse of
Insert living celebrity your locality claims
at a local restaurant.
You know, I once met that person at an
Insert local grocery store chain.
Wow, it is wild to realize that that person is a person who shops just like the rest of us in this area.
It sure was neat to see that person, but in my opinion, and maybe it's just me, but I don't think there's anything more beautiful than seeing the sunrise over
Insert local landmark.
That is so true, Julianne. Maybe the only thing that makes me happier is to see the smiling faces of our wonderful clients and colleagues, and that makes it so tough to present in this virtual format this year.
That's true, AJ, but I'm hopeful we'll get the chance to see all of you very soon. And don't worry, the first round of
Insert favorite local food
is on us.
It sure is. Well, now that we've had a chance to sufficiently pander to each of you in order to engage you in the rest of the presentation, we're going to move on with our substantive presentation. And in order to do that, I also want to remind you that we can and should receive any questions you have, and we'll have the opportunity to answer them live today. So if there's anything from the earlier presentations or anything you hear coming up, please do type it into the Q&A section at the bottom of your screen. And next up, to address some hypotheticals surrounding the ongoing impact of the pandemic, we have my colleagues Bill Hughes, Sunny Nolan, Chris Otley, Donna Pryor, and Avi Meyerstein. Take it away, Sunny and Bill.
Thank you, AJ and Julianne. My name is Sunny Nolan. I'm here in a satellite office, as you may well be able to tell, in St. Louis, Missouri. I'm one of our labor and employment attorneys.
Hello, everyone. I'm Bill Hughes, and I'm actually in the downtown Milwaukee office of Husch Blackwell.
Bill, I don't know. Ever since we've been doing this work from home, I haven't had enough Zoom calls, and I'm certainly not getting any COVID questions. I don't know about you. Is there anything you are missing?
Well, Sonny, it was certainly true as of about mid-March. I didn't have any COVID questions and had a very infrequent encounter with Zoom. But since then, our clients and you and I and the entire Husch Blackwell labor and employment team really has been inundated with COVID-related questions. We didn't have any, not surprisingly, didn't have any COVID experts to turn to for ready-made answers. So we relied on each other to share questions, come up with answers, and develop best practices. Today, we're going to go over some of those real questions from real clients and offer recommendations and solutions for how we would suggest you handle these situations. Of course, we're not going to use any client names, and all client confidences will be fully protected.
Well, exactly, Bill. Some of the things that we're going to cover today will be our old favorites, travel, questions like that, business and personal. We get that a lot. But some of them are new, virtual schooling and things of that nature. So with that, Donna and Avi, let's get started.
Hi, everyone. I'm Donna Pryor from the Denver office. I'm in the Labor and Employment Group, and I focus on workplace safety and health.
Hi, all. I'm Avi Meyerstein. I work with Donna, although we're in different places. I'm out of the Washington, D.C. office, also focusing on workplace safety and health. And to start us off in this segment, I'm going to put a question to Donna here, something that we get from our clients. We have an employee who's required to travel for work. And we didn't know it, but the employee recently took a COVID-19 test and then got on a domestic flight before having the test results. Do we have to report the behavior to the airline to let them know that the employee had this test outstanding? And if the employee tests positive, do we have an obligation to report that test to someone? And if so, to whom? What do you say, Donna?
Sure. So COVID-19 testing sites report the results to the appropriate state or local public health department. So that's the answer to that question. So on the airline front, an employer would have no obligation to report anything to the airline, first of all, because they don't even know if the employee has tested positive yet. But second, even if they did test positive, you're under the obligation to keep confidential employee information confidential. So it wouldn't be prudent to call the airline with that medical information about one of your employees. At best, you can encourage, just for ethical reasons, you can encourage the employee to call the airline and self-report so they could do contact tracing. As far as notifying others, employers should inform other employees about possible exposure in the workplace, but again, maintain that confidentiality as required by the ADA and state privacy laws. So this means you don't give out the name of the employee, but you could give out some information about them, maybe where they were working, which floor, which shift, as long as it doesn't give out their identity. Even if coworkers try to guess, please don't confirm the identity of that person. Also, we're seeing a lot of clients get either verbal or written waivers from employees that say you can use their identity and tell their coworkers that they tested positive. We are encouraging folks, even if you get just a verbal waiver, to write back in an email just to say this is to confirm that you've given us a waiver and we can share your name with some of your coworkers. Also, make sure that you don't have any state reporting requirements. Certain states like New Mexico OSHA has a reporting requirement that you have to report within 4 hours of finding out an employee has COVID. And speaking of OSHA, our last slide talks about what you need to do to report to OSHA if you have a COVID-19 recordable illness. You only have to report a recordable illness on your OSHA 300 log if you have a confirmed case of COVID-19. It's work-related, which is kind of the big question, and it involves time away from work, death, restricted duty, transfer to another job, or medical treatment beyond first aid. So the big question is going to be, is it work-related? And how do you figure that out, being that we're not all doctors, is going to be tricky, but OSHA knows that we're not all doctors, and they're asking you to look at evidence as far as, is anyone at home sick? Is anyone else on the shift sick? Do you have other cases of COVID? And other kind of evidence to help you make a finding of whether or not the employee actually contracted COVID-19 at work. And now I have a question for you, Avi. So all of these scenarios are kind of modified from a lot of questions we've been getting from our clients. So this one is about follow-up on COVID-19 testing. So in this case, an employee tested positive for COVID-19, and 2 weeks after recovering from her symptoms, she's still testing positive. Can we require a negative COVID-19 test or positive antibodies test before allowing her to return to work? What do you think, Avi?
Well, I think there are a couple answers here. One is whether you can, and the other is whether you should. And so let's cover the can part first. As you know, the CDC, the Centers for Disease Control, has been the key source that all of the state and federal agencies have been relying on. And so far, the CDC says we still don't know if having COVID means you're immune from getting it again. And so there are two different kinds of tests that are done. One is the viral test that tests to see if you have an active infection. And that's the one that'll tell you if you're contagious and you need to stay home from work. The other one is a serology antibody test, which tells you if you have the antibodies in your bloodstream, which means you had COVID in the past. And so since we don't know if antibodies means you're immune, the CDC has not recommended antibody tests, and the EEOC, when it comes to employers, has basically said, yes, you can have a viral test and you can require it to make sure that employees are not infected before they come to work or return to work. But no, you can't require an antibody test because we don't know if it does any good. Now that's the can part. The next part is the should. And the CDC has basically issued guidelines that have updated to say that they're no longer recommending that you use tests in order to determine when people return to work for most employees. And so in that case, you do your return to work decision based on symptoms. If the employee has symptoms of COVID-19, then you end their home isolation. They can come back to work at least 10 to 20 days after the onset of symptoms and 24 hours after their last fever without medication to reduce the fever, and the other symptoms improve. So you want to have all of those conditions met if they had symptoms. The asterisk by the 20 is if they're a immunocompromised person, then there's a longer time period recommended. If the employee had no symptoms at all, then they can end the home isolation 10 days after the first positive test. So that's the methodology for determining when someone can come back to work. And now we're going to throw it back to Sunny.
Thanks, Donna and Avi. One of the things that we are hearing a lot about, a lot of the questions that we're getting from employers, not surprisingly, it's the beginning of the school year, is about how to accommodate parents who have children who are doing virtual school. In some areas, virtual school is the only option. Other areas, it's not so much. But in those areas where everyone is going to school virtually, employers really want to give parents the flexibility to work from home or to have a different kind of schedule. And the question is, if they are doing that for caregivers, parents, do they have to do it for everyone else? And the answer is, while caregiver status is not specifically enumerated in the federal law, it is something that employers will need to be careful with. You can absolutely give parents or caregivers the flexibility to assist their children with virtual school by working from home or by working in some other flexible type of arrangement. However, one thing that employers really want to be careful with is making any sort of assumptions about who is being a caregiver. It's not uncommon for an employer to think that the mom will be the primary caregiver. And in some cases, they want to help the mom have that flexibility. In other cases, it can hurt the mom's career as well. Now, more than ever, we have very non-traditional families, and we have both parents and extended family, including grandparents, who are also caregivers. So that is something that employers want to be careful about. If you're making those kinds of assumptions, including whether someone can travel or get their work done because they have children, and you want to make sure that you're not doing that based on gender. As mentioned earlier in the Bostock case, you should not be making any sort of assumptions that are based on gender. Sex stereotyping, I think it comes up a lot with women, but it's also with men as well. Moreover, if you are looking to only accommodate parents, you will run into an adverse impact situation because older people or younger people, for that matter, and there are some jurisdictions that protect young people, older people will be disparately treated. They often will need those same kinds of accommodations for different reasons or for caregiving. Grandparents are absolutely getting involved. One other thing, or a couple of other things that employers should be on the lookout for, and that is negative comments about caregivers. It's not uncommon to hear someone wondering if someone is as committed to their career, if they are staying home and doing virtual school. And you'll want to be really careful. That could be the basis of a discrimination claim. And that's true whether it's a man or a woman. So employers who haven't gone back to the office yet, and you're making those plans to do so, one other thing you might consider is sending out a questionnaire to your employees who will be returning to the office and determine whether they will need an accommodation. And you can ask whether that's for caregiving or for a disability. And that allows employers to go ahead and get started in that interactive process that they'll need to undertake, gives you plenty of time to prepare for those requests and determine whether you can give your employees the flexibility they need. So with that, I will turn it over to Chris and Bill. Thanks.
Thank you, Sunny. And hello, everyone again. Good to be back with you. As I mentioned before, I'm Bill Hughes. I'm with the Milwaukee office of Husch Blackwell. This scenario involves a situation with an employee who, for whatever reason, is consistently getting tested for COVID-19. As far as we know, he doesn't have any symptoms and has not been exposed to someone with the virus, so it's a bit perplexing to us. Nevertheless, he's also able to get a physician to recommend that he quarantine. So we're getting these quarantine notices for this individual, and we need him at work. He's creating a problem by not being at work, putting a hardship on other employees. So the employer's question is, what can we do? Can we terminate him? Can we replace him? What rights do we have? Next slide, please. First thing we recommend is that you engage in the interactive dialogue with the individual. Although the term interactive process is typically used in connection with accommodations under the ADA, we think it's a great idea to do in a lot of situations, including this one, where we are sort of at a loss for an explanation as to why the employee is engaging in this behavior. So HR should someone should contact the individual and find out what's going on. Why is it that he's constantly going for these tests? Why is it that he's going to his physician and getting quarantine orders? What is he telling the physician about his condition that entitles him to get quarantined? That would help us in deciding what way to go. If contrary to the scenario, the individual actually does have symptoms, well, obviously we don't want that individual reporting to work. And because of the fact that he has been informed by a physician that he is to be quarantined, he does have rights under the Family First Coronavirus Relief Act if you're subject to it. And you're subject to it if you have fewer than 500 employees. So based on that information, the employee would be entitled to 80 hours of paid sick leave under the Emergency Paid Sick Leave Act. And you'd have to give him that right and that entitlement to that paid sick leave. Even though you're suspicious, even though you question the need for the leave, he's qualified for it based on the information he's provided to you. If you're not subject to the FFCRA, then the question becomes, what do you want to do with this individual? And again, it depends on the information the individual provides to you. If there's a very real concern there and something that would indicate he shouldn't be at work, you obviously don't want him at work. But if it's a case of an employee gaming the system or an unwarranted fear or a warranted fear of catching the virus, then you have different obligations and rights with respect to that employee. One thing you should consider, two things you consider, is whether he has any rights under the Americans with Disabilities Act or under the Family and Medical Leave Act. If the condition is such that it's created some type of physical or mental impairment, maybe he's got an emotional issue created by the virus or the fear of the virus, there could be a situation where you have to at least have to consider whether he's entitled to an accommodation under the ADA. And if the situation is such that it could be classified as a serious health condition, the employee would be entitled to leave under the Family and Medical Leave, could be entitled to leave under the Family and Medical Leave Act. So you need to walk through that scenario. If you are subject to the FFCRA and you've determined that he's not entitled to any relief under any other laws, you can go ahead and terminate, release him from employment. Maybe keep him on an indefinite leave of absence if you don't want to terminate. But you should be aware that you should treat him like you would treat anyone else in a similar leave type of situation. so you aren't subject to a retaliation claim under the FFCRA. The bottom line is employees aren't entitled to an indefinite leave based on a fear of contracting coronavirus. We can understand that, but they're not entitled to that indefinite leave. You can take action to terminate after you've applied your leave policies in a consistent manner across the board, and after you have all the relevant information you need regarding this employee's condition, so the employee can't later claim that in lieu of termination, you should have taken some action to provide an available leave, a required leave under the law, or an accommodation, and then you're subject to a claim from the employee. And with that, I'll turn it over to Chris.
Thank you, Bill. I really appreciate that succinct summary. My name's Chris Otley. I'm at the Denver office of Husch Blackwell. And what I wanted to talk about was a hypothetical scenario where your employee is engaging in risky behavior outside of the workplace. So this is separate from any sort of behavior that might be taking place in the workplace. Needless to say, this is more than a hypothetical, because I think we're all aware that during the time of coronavirus, a number of individual employees have different levels of risk tolerance in terms of what sorts of behaviors they're engaging in outside of work, whether it's doing things like going to concerts and gyms and amusement parks, or even doing things like going to church services or political rallies. And so not an infrequent question that employers have been asking is, what can they do to ensure that their employees are engaging in safe activities outside of the workplace, so that when they come into the workplace, it's not actually increasing the risk of safety. The number one thing to know is that you need to approach any of these sorts of situations with caution, because the risky behavior of your employee outside of the workplace could in fact create a number of risks for the employer within the workplace. Generally speaking, I think that most employers know, and I think most employees have an understanding, is that employers are able to regulate and monitor what their employees are doing in the workplace. But generally speaking, they should try to avoid trying to regulate and monitor what an employee is doing outside of the workplace. During the time of coronavirus, obviously, keeping those two areas separate is a little bit more difficult than in normal situations. So some of the risks that an employer might run if they do become too intrusive in terms of trying to monitor and regulate what their employees are doing is they could start infringing upon an employee's reasonable expectations of privacy. Generally speaking, most employees recognize that they are allowed to engage in lawful behaviors outside of the workplace. As I just touched on, some of the other areas that we might touch on that might be put an employer in the risk zone is if they start trying to monitor and regulate what employees do with respect to attending church services or engaging in religious practices, perhaps engaging in political rights, social justice movements like Black Lives Matter, or political rallies, or any other types of political activities. Certain states, including the state that I'm in right now, Colorado, have specific statutory laws that prohibit employers from trying to prohibit an employee from engaging in lawful off-duty conduct. That lawful off-duty conduct, if it's related to the workplace, is allowed to be regulated and monitored. But at the same time, those are those are ambiguous areas and can create the risk of claims by employees. The best analogy to this, and something that almost all employers are aware of right now, is social media. Generally speaking, our advice to most employers is stay off of social media. Don't monitor what your employees are doing on Facebook or Twitter or Instagram, because once you learn that information, you can't unlearn it. And that creates itself some risks that you probably don't want to monitor. So given that there are a number of risks associated with trying to monitor and regulate what employees do outside of the workplace, what can you do if you feel that it's necessary as an employer to make sure you're managing the risky behaviors that employees might be engaged in? So the primary rule is that you're going to want to set very clear expectations for your employees. And to do that, you need to do at least two things. Number one is you need to make sure that you're consistent. So for example, if you're trying to prevent employees from engaging in social justice type protests like Black Lives Matter, you're also going to have to make sure that you're consistent and make sure that your employees don't engage in political rallies. If you don't have that sort of consistency, you open yourselves up to all sorts of claims of not just unfair treatment, but perhaps even discrimination or retaliation. Secondly, you're going to want to make sure any expectations that you do set for your employees are going to be job related. And that is going to vary depending upon what kind of job the employee actually has. So for example, employees that are working in the healthcare space are more likely to have a job-related reason to make sure that they're safe than perhaps somebody in an office environment or a blue-collar environment. Third, consider drafting a policy. Anyone who's ever worked with me knows I actually don't enjoy or think policies are particularly effective. But in this sort of a situation, a policy is going to help you meet those two previous goals of making sure there's consistency and job relatedness. There's just so many different decision makers within large organizations. It's going to be important that an organization maintains that consistency throughout, and a policy might be effective at doing that. Another thing to keep in mind is that, again, employers have wide discretion in monitoring and regulating an employee's behavior within the workplace. So continue to emphasize that. Continue to emphasize social distancing and wearing masks and engaging in the sorts of behaviors that most employers already are emphasizing to their employees. That's going to put you in a more consistent position with trying to monitor an outside employee's behavior. Fifth, make sure that you encourage your employees to disclose if something has happened in their family lives or their outside lives that might have an impact upon their safety. For example, if they've been exposed, make sure that employees feel that they can disclose that information without being retaliated against. And finally, the last point that I'd like to make that my colleague Donna Pryor is going to pick up on next is consider the effectiveness of any restrictions that you might put into a place. For example, I think we are now at a point in the coronavirus pandemic that we know it may not be particularly effective to have travel restrictions in place unless it's required by law. So consider whether or not it's actually going to be something that's going to promote the safety of your workplace or the effectiveness or productivity of your workplace. With that, I'm going to hand it over to my colleagues, Donna Pryor and Sunny Nolan. Thanks.
Thanks, Chris and Bill. I'm back with Donna, one of our workplace safety experts. From the beginning, Donna, travel has been a question that has come up a lot from employers. You know, restricting business travel from the beginning, that seemed to be a little bit easier, but what to do now? Employers don't want to lose the competitive edge, and they've been really unsure what to do around personal travel. Can you share what some of the best practices are right now related to business and personal travel?
Sure, Sunny. Remember back in March when we were really warning clients about China and Italy and taking a cruise? I wanted to show you the slide from the CDC website about the current areas that are high risk on the globe, which you can see is most of the globe, with the exception of some Southeast Asia in the lower right, in Laos, Thailand, and Burma. The gray little area above, or big area above Iran, is Turkmenistan, and that's only gray, along with North Korea, because the COVID data is unknown, and so there's still travel advisories for those areas. So really, unless your employees are traveling to Laos, Thailand, or Southeast Asia, you know, most of the rest of the world is going to be a high risk area. So as Chris stated earlier, travel restrictions for all employees are going to be really hard to enforce. What we found is that most employers have abandoned domestic travel bans for work-related travel. Personal travel, it's really not a one-size-fits-all. So we're finding some employers are all over the board on this issue, and it really depends on industry. Some employers are looking at destination, which is tricky because, some folks, are concerned. Sometimes you're concerned about Florida. Sometimes you're concerned about Texas. Earlier in the year, we were concerned about New York. So that's kind of a moving target. And so you're going to have to be changing or looking at policy changes constantly based on hotspots around the country. Also, some employers are requiring self-reporting for travel. And it's interesting because folks who are concerned about their safety are reporting folks who don't self-report because, say, they're posting their travel to Florida on Facebook or some other form of social media, and other folks are seeing it and then reporting them. So what overall we are encouraging our clients to really encourage the CDC safe practices that we've been hopefully practicing all along. That means social distancing when you're traveling, making sure you're wearing a mask and you're washing hands or using hand sanitizer, Also be mindful that some states have travel, or at least self-imposed quarantine requirements, orders for folks who are traveling in their state. Earlier on, I know that Texas wasn't allowing folks to travel over the Louisiana border unless they self-quarantine for 14 days. Now we're looking at those similar self-quarantine orders in New York State and Hawaii. So encourage employees to follow those local and state quarantine orders. International travel and cruises is kind of a moot point right now. A lot of employers are still requiring 14-day quarantine after international travel and cruises, but honestly, folks in the US aren't really able to travel many places right now, and a lot of cruises just aren't happening. So I think largely that's a moot point, but like all of these COVID issues, it's going to be evolving, and we encourage everyone to keep on checking that CDC website. It's so helpful for more information on all of this. So now, Sunny, I have a question for you. So many of us have these choices. Some of us don't when it comes to returning to school. Do we have an option to just stay virtual, or can we put our kids back in school either full-time or part-time? So this question has come in a lot. So in this case, the client has an employee whose job can't be performed from home. He has the option to send his child to school in person or virtually this school year, and he chooses virtual school and requests Families First Coronavirus Relief Act leave. So three questions here, Sunny. Is the employee eligible for FFCRA leave? What if he refuses to return to work, and what are the company's options?
Yeah, you're right, Donna. We are getting that a lot. We'll go ahead and go on to the next slide. I think a lot of employers know, but it bears repeating, that this employee is not eligible for this protected leave because there was another option, and the school is open. The school has to be closed due to COVID in order for the employee to qualify. However, as far as what do we do now if the employee won't return to work, I'd be very careful moving forward with any sort of termination. At that point, you really need to start to engage in the interactive process and make sure you understand why the parent might be choosing a virtual option. Now, some employees are concerned that their child may become ill, contract COVID. But according to the EEOC, and they just released new guidance on September 9th. So, like Donna was saying, well, September 8th, I think, like Donna was saying, you need to keep up with the EEOC and CDC as much as possible. But even if the parent is concerned with that, according to the EEOC, the employer does not have an obligation to accommodate the employee relative to FFCRA. But there could be another kind of accommodation. And as I mentioned earlier, related to the interactive process, you want to get started on that as soon as possible. Finding out what type of accommodations individuals are going to need. One misconception that both employees and employers have right now is that once they allow, employees to work from home, then do they always have to allow them to work from home, like in this particular case? And that is not something that employers have to continue doing, but they may choose to do so if it doesn't cause any sort of hardship. And the same goes for an accommodation related to disability. I think employers, they've been asking me this a lot. We allowed them to work from home. Now our employees believe that they can work from home for, really any reason. And you still go through that interactive process. The EEOC has been very clear that it might not always work. It's a potential temporary option. Employers are allowed to give temporary accommodations until they can figure out something more permanently. So definitely want to be careful to move forward with any sort of termination, want to engage in that process and see if there is an accommodation for the employee.
Great.
With that, it's on to Avi. Thank you.
Thank you, Sunny. Well, here's our next question. We're going to talk a bit about vaccines. The question on everybody's mind: can we require our employees to get a COVID-19 vaccine when it's available? Boy, a lot of things to talk about here. First of all, just think about how complicated this whole thing's going to be. Everybody's thinking about vaccines as the saving grace of this whole situation, but think about how tough it was to get people to wear masks in some places. Vaccine injections, it's going to be way tougher. It's going to take a ton of time. And you can see on the screen here, this is a flow chart that the CDC has put together, an update of its usual pandemic vaccine distribution chart. There are a lot of stages here. There are going to be phases. There's a lot of discussion now about the different phases, about who gets vaccines first. Like, think about the medical workers getting it first, and the healthy adults getting it last. So this is going to take some time. It is not an instant panacea. But thinking about the question about whether an employer can require the vaccine, the answer is we really don't know yet, because this is such an unprecedented situation. If you take the current status of guidance that we've seen from the EEOC, the normal exemptions are still in place, where some employees can claim to be exempt for medical or religious reasons, and you're supposed to try to accommodate them. In the case of COVID-19 in particular, there's been some guidance to update that. For example, someone with a medical condition may not be exempt if you can't accommodate, and they would pose a direct threat to the workplace under the ADA. And in the case of a religious belief, it may not be exempt if it's going to cost more than a minimal amount by the employer to try to accommodate. So that's the general guidance, but we really haven't seen an answer yet about this pandemic and how the EEOC will handle it. We suspect because there's no vaccine yet, and once there is one, we probably will get some more information from them. Think about all the other things that could come up. Someone who has ethical objections, not religious ones. Someone who's afraid of the vaccine because it was developed so quickly and is so new. So we really don't know the answer about whether it can be required, and we really haven't seen the full landscape of issues play out. Stay in touch for that when the vaccine actually comes out. But think about a few more things to have in the back of your mind, factors you may need to take into account. Some employers are going to possibly need union consent if you've got a collective bargaining agreement before you can require vaccines. There's going to be a question about some people claiming that you're liable for making them get a vaccine because they'll claim that they got sick as a result. If someone gets sick, are you going to have workers' compensation claims? And if someone claims that the vaccine was done too quickly and is not safe, are they going to be able to refuse to work under the Occupational Safety and Health Act, and will that be protected? So there are a lot of questions here, many more questions than answers. But we want to know what you think. So I'm going to toss it back to Julianne and AJ, and they're going to walk you through a poll about vaccines.
Thank you very much, Avi. And as Avi mentioned, we are going to start with the poll question next. In order to qualify for continuing education in a certain rectangular state to the west of Missouri, we have to have 3 poll questions for our audience, and this is the first one. Is your organization planning to require at least some employees to get a COVID-19 vaccine when it becomes available? And your options are: yes, we are planning to require a vaccine; we are considering but have not made that final decision; maybe leadership has not yet discussed it; and then no, we are not planning to require a vaccine for any of our employees. So please do take a moment to get your answers in, and we'll take a look at how our audience is considering this issue. Okay, so the vast majority of you are in those last 2 boxes. It's possible that you haven't yet made a final decision, or you have decided already that you are not going to require it for anyone in your workforce. And obviously there will be a lot of moving parts, as we've discussed, as these vaccines get rolled out, and we'll know a lot more soon.
No doubt. So now we're going to take our second break of the day, which will last 5 to 6 minutes. So feel free to step away if you'd like.
And for those of you who stay, we've put together another practical presentation that we think will be helpful for you.
Certainly, this has been a difficult year, but we have consistently heard from clients, employees, and our family members that the key to handling these challenges has been to communicate often and effectively.
That's right, Julianne. And as a result, we at Husch Blackwell have made a real effort to learn to leverage all of the many ways that are available to us to communicate virtually in 2020. Of course, some of this technology can be a little bit tricky and feel a little bit foreign. So we decided we would reach out to some experts in new media, and we found some in our own virtual office mates.
We'll start with a short video captured the other morning in the home of our St. Louis colleague, Brittany Falkowski, as she prepared for an important video conference call.
I have a really big video conference meeting this morning. How do you think I look?
You can't wear patterns on Zoom. You need a jewel tone.
You're right. Okay, now I'm ready.
Mom, that line's all wrong.
The lighting now? What about this?
Perfect. One more thing.
What? Oh, are you sure?
Positive.
Okay.
Hi everybody. Sorry I'm a few moments late. I had a couple technical difficulties right before logging on.
So some useful tips there for all of us. Unfortunately, you will not be hearing from Brittany today, primarily because we knew that with the help of her online video style consultants that she would make the rest of us look, well, terrible. And it was a harsh reminder to me as I wear my pattern shirt today.
Oh no, you look fine. Like many lawyers, AJ's written communication is a lot stronger than his appearance. But even he needed some help figuring out the best way to use modern means of communicating to handle a difficult opposing counsel and to reach a positive result for one of our clients.
Hey, Evie Joe. I was thinking I need to start using emojis more when I work on my cases. I think that might help me. Can you help me figure out what emojis to use to send some messages?
Mm-hmm.
Okay. See, I just got a message that says, we reject $15,000 and will take nothing less than $100,000. What emoji should I send back to that?
Money.
Okay. Money, anything else?
Medicine.
Money, medicine, what else?
And a face, a silly face.
Okay, let's try it. Okay, yeah, they already responded. They said, what are you doing? Was this meant for me? Please respond to our demand. What do you think I should say to that?
You should use a half sun moon and half dark moon.
Are you sure?
Yes.
All right, they responded. This time they said, please stop. This is very unprofessional. Just tell us what your client wants to do. Okay, what do you think I should say to that?
It's time to send the smiling poop.
Poop, isn't that kind of rude?
It's smiling.
All right, here we go. Hey, they responded. They said, fine, we give in. We'll take the 15,000. We did it.
Thumbs up, smiley face.
Heart.
Heart.
So I know what you all are thinking. Doesn't having your daughter participate in settlement negotiations affect the confidentiality? And we have a solution to that as well. We've actually hired each of our children as employees of the firm in order to ensure that they are covered by our attorney-client privilege and confidentiality. And that actually worked out pretty well in other ways because it allowed us to use them as child actors in these videos without running into any sort of minimum wage violations.
Next, we're going to see what happened in the house of Eric Eisenman, a partner in our Milwaukee office, who is the chair of our labor and employment practice group, when he tried to learn the ins and outs of a popular video sharing app.
Dad, what are you doing?
Oh. Hey, Cora. I'm trying to learn TikTok.
Why are you doing that?
Well, I've heard that there are lots of savvy clients who are looking for representation on this app, but I just can't quite figure it out.
Oh, let me help you. Here you go.
Wait, what did you do?
I deleted TikTok from your phone.
You deleted it? I thought you said you were going to help me.
I did help you.
And you may find this hard to believe, but Eric Eisenman is an even better lawyer than he is a dancer.
He sure is. And now we're going to send you to our last group of presenters to address hot topics facing employers this fall. John Anderson, Anthony Grice, Hillary Klein, Kevin Kronka, Kate Levesque, and Paul Powler.
The coffee giant is now coming under fire for a policy that bans their employees to wear any Black Lives Matter apparel.
Social media is a vital part of promoting your business. Facebook, Instagram, Twitter, Yelp, Foursquare, LinkedIn.
For millions, the reality of working from home could be permanent.
Herman Miller employees will receive Election Day as a paid holiday.
Hi, I'm Paul Powler from the Kansas City office. As you probably gathered from that last clip, our last segment is going to talk about some topics that have been in the news, but might have been backburnered during this time of a global pandemic. We've got a lot to cover, so let's go ahead and get started. I'm going to start out first with the new reality of work from home. This is our day now. We're working at home. We've got our fancy artwork on the wall. We've got our makeshift desks and work areas. And we've got the ever-present danger that the kids or the dog may barge in at any moment. But it works. For the most part, it works. It works better than many or most of us thought that it might. And so if this is our new reality, there are some topics we need to talk about. The first, work from home as a reasonable accommodation under the ADA. The monitoring of remote employees, and timekeeping for hourly employees who may be working from home. Let's go ahead and get started first with the ADA, the reasonable accommodations. Where we anticipate this coming up in the next 6 months or a year, if it's not already coming up for you, is folks coming in with stress or anxiety related conditions or depression, or needing to be home while they coordinate medications for cancer treatments, things like that. Or compromised immune systems, where their doctor tells them in this pandemic or the next healthcare crisis that they need to be home in order to try and limit the spread of a disease. So those are all times when we may be asked for a reasonable accommodation of working from home. And as we all know, the ADA requires employers to provide reasonable accommodations to allow employees with disabilities to perform the essential functions of their job. And there are 3 elements of that. That's to be an employee with a disability, and that's a low bar these days, needs accommodation in order to perform the essential functions of the job, not just wants it, but needs it to be able to perform the essential functions of his or her particular job, and that can be accomplished with the reasonable accommodation. And finally, obviously, it's that it be reasonable. And for years, under the reasonability prong, for years employers have bristled about work from home as a reasonable accommodation, saying it's not as productive. Employees aren't as productive. We need in-person interaction. But now, after 6 months and how it's worked, it's hard to say that it absolutely can't work. And we need to throw work from home at least into the mix. So 2020 may have changed what's reasonable, what's considered reasonable under the ADA. But remember, that doesn't mean you have to grant every leave from home request. Doesn't mean everyone is entitled to it. Line workers, truck drivers, folks who do anything other than an office job, and maybe not even all of those, it may not mean that they can accomplish their essential functions working from home. And if they don't, then they're not entitled to it because it's not a reasonable accommodation. And second, please keep in mind, that employees are not entitled to their preferred accommodation, even if it's reasonable. If there's another reasonable accommodation that works better for the employer, we can go that route. And it may be things like frequent breaks or intermittent leave of some type, or modifying the workspace. If any of those are a preferred accommodation for the employer, you can substitute that for work from home leave or work from home accommodations. So the three-step strategy for evaluating these requests is much like it's always been. In advance, review the job descriptions and the essential job functions of each job to make sure they're accurately reflected. Engage in the interactive dialogue. If you've heard me talk about the ADA before, you know I pound on the table about the interactive dialogue. Talk with the employees about the condition, about what they need and what might be reasonable to try and to help with the essential functions. Maybe something can be worked out. At the very least, the EEOC looks incredibly favorably if you have engaged in the interactive dialogue, even if you ultimately turn down the request given to you. With that, evaluate the options and make the best call in the circumstances. Moving on then, our next topic is monitoring of employees who are working remotely or working from home. There are lots of legitimate reasons to do that. Protecting against malicious cyber activity, protecting your intellectual property, and ensuring that the employees who are working from home, essentially unsupervised, are actually productive and engaging in appropriate activity. Not looking at inappropriate websites, not sending inappropriate emails, things like that. So there's lots of legitimate reasons. And there are lots of ways you can monitor employees. You can monitor their internet activity, their productivity, how much time is idle, tracking file access, their physical location, if they're actually at their home or elsewhere, keystroke activity, what they're typing, and turning around the webcam and viewing them actually from the webcam at their desk. So there are lots of ways that that can be done. Can it be done? Can it be done legally? That's pretty invasive stuff. That's pretty heady stuff we're looking there. Red flags are undoubtedly going up with our HR professionals. Can we do that legally? The answer is probably yes. Now, do you need to? Do you want to? Those are separate questions, but can you legally do it? Probably so. The Electronic Communications Privacy Act limits a lot of cyber stalking and related activity, wiretapping, video surveillance, lots of surveillance type activity. But there is a big and a well-defined exception in the employment context for business use and with the consent or with the consent of employees. Now, we have to always keep in mind state laws. California and Illinois come to mind. They have two-party consent or all consent provisions. But even with those, in general, there are some practical considerations for monitoring that can keep you out of trouble. One, and the most important, is to inform employees of monitoring, to eliminate the reasonable expectation of privacy. If you tell them we're monitoring you by webcam or we're doing whatever the monitoring we're doing, then they can't have a reasonable expectation of privacy. If you've got the administrative staff to get consents from everybody, that's great. But at the very least, inform them of the monitoring that's going to occur. And second, use the least invasive means necessary. If you don't need to monitor their webcam, do it in some less invasive way. And certainly, when you see that they're engaging in personal activity, that's enough to note that it's personal and not work-related, and stop monitoring the actual personal activity. So finally, we're going to move to timekeeping. And this has become such an issue for work from home folks that the DOL, the Department of Labor's Wage and Hour Division, recently in August put out its Field Assistance Bulletin dealing with exactly these issues. Now, it didn't tell us anything particularly new, but it's a good reminder under these circumstances. First and foremost, an employer absolutely has the obligation to accurately record time worked and to pay for that time. Can't slough off that burden to the employees. Now, in order to do that, many employees use tracking software. That's not required, but it's permitted. All that's literally required is that you get the accurate time. That can be done by email, phone call-ins, whatever you need to track and record the accurate time. The red flags, the trips and traps, Beware of work outside of normal hours, either due to the employee's convenience or because they get phone calls or things like that, but answering emails, working on a report after hours, things like that. These are all times that employees can work extra hours and result in overtime. And we need to track and record and pay for those hours. So this is a good time to update policies regarding expectations. And first, that is to reiterate that we want employees to record all their time and to be paid for all their time. But having said that, it is absolutely fair and reasonable to set expectations for when they're going to do it, how much they're going to do it, and if they're going to be recording overtime hours, they get advance approval. That's all perfectly appropriate. And if they don't do it, obviously, after they've been told, then we can discipline if necessary, and hopefully that'll avoid some of these problems. So that's the new reality of work from home. We have covered a lot in a short period of time. I'm out of time now, but if you have questions or want follow-up, feel free to reach out to me or your Husch Blackwell contact. Be happy to help you. So now I need to send it over to Kate and Anthony, who are going to talk about diversity and inclusion and its impact on the workplace. Take it, guys.
Thanks, Paul. Hello, everyone. I am Anthony Grice, and along with my colleague, Kate Lebec, we're going to talk to you today about diversity, inclusion, and corporate culture. Everyone's aware of the difficult social and political times that we're currently in, and we understand that companies across the country are attempting to determine how to make their workforce more diverse and inclusive. And so today we're going to talk to you about some of the issues that we have seen and some of the solutions that are available to you to make a more diverse and inclusive corporate culture. I first want to talk to you about some proactive steps that you can take to promote inclusiveness in your workforce. The first thing that you can do and should do is review your anti-discrimination and harassment policies. It's probably already in your to-do list, but it's now even a better time to do it, particularly if you're in a state where you have to periodically review your policies anyway. Make sure those policies are tight and up to date and applicable. The next thing is to increase your focus on diversity and inclusion training. You're most likely already doing training on discrimination, harassment, and retaliation, but you can build out those trainings and presentations to include diversity and inclusion training, which would focus more on how to be more inclusive and respectful in the workplace, and also include implicit bias training in there as well. The last proactive step that you could take is to consider policies and procedures for diversity in your hiring efforts. For example, one thing that you could try is to remove names from your resumes that you're considering so that any implicit bias based on an ethnic name is excluded from the process. But at the end of the day, you want to make sure that you are casting a wide enough net to include and attract diverse individuals who are also the most qualified person for the job. Kate, do you want to talk about how to respond to complaints in workplace behavior?
Yeah, that sounds great. I think that these investigations and responding to complaints has always been a part of what we do, but it's become even more important now. We've noticed an uptick, and probably you've noticed an uptick in complaints from both internal and external sources, and those complaints involve conduct both within and outside of the workplace. And so you want to make sure that you are taking the opportunity right now to look at your policies and procedures and how your investigations are conducted, and training your investigators and your managers to ensure that those investigations are conducted in a timely manner. You don't need to have policies with specific timelines. In fact, I don't recommend it, because ultimately something's going to come up and it's gonna get lost in the shuffle and you'll miss one of those deadlines. But you do want to know kind of the basic steps that an investigator is gonna follow as they're looking into any complaints or concerns. You also want to consider retaining outside investigators when it's necessary. To the extent there are any systemic complaints or complaints of systemic issues within the organization, that might be a time to bring in an outside investigator to help with that feeling of neutrality from people who are complaining. And then finally, you want to train your managers. Managers should know how to identify inappropriate conduct and triage and elevate complaints. You want to make sure that your managers are not letting the little things go or ignoring the complaints that come forward from employees when they say something like, I want to let you know this, but I don't necessarily want you to do anything about it. Managers should definitely bring that forward. And then finally, don't forget about those internal closure letters to let the employees who complained know that you've completed your investigation. You want to maintain confidentiality, but you want them to let them know that you took it seriously. So Anthony, how does that differ when a complaint comes from, say, a third party or is related to off-duty conduct?
Absolutely. A lot of what you said applies, but there are a few different considerations that you want to consider when the conduct is off duty. The first thing that you want to consider is you absolutely want to investigate the complaint, but you don't want to make any knee-jerk reactions. And so with workplace behavior, there are probably internal investigations and investigation steps and processes that you already have in place, but you may not have those things in place as it relates to off-duty conduct. And so be very deliberate about not making a knee-jerk reaction to the complaint, particularly if it's going to be made by an outside entity. But along with that investigation, make sure you do find out what exactly the conduct was, whether it was some sort of action or if it was a communication or social media post. Today, we're seeing a lot of political speech and social commentary out there. And so once you find out what that action is or political speech or commentary, seek legal review from outside counsel. There are two benefits to that. One is that legal counsel can give you some context because we have been seeing these quite often over the last few months. And so we can provide legal context as to where exactly that speech fits in terms of whether it's something actionable or not. The second thing is that we can do a review and help you make sure that you're not running afoul of any state laws regarding states that allow certain legal off-duty conduct. And so you certainly don't want to take action in a jurisdiction that allows for certain off-duty conduct where that conduct is legal, particularly around speech-related issues. And the last thing that you want to do for off-duty conduct is be very deliberate about maintaining confidentiality in a similar way that you would with workplace behavior, because for off-duty conduct, not only are you dealing with the legal aspect of this, but you also have the business reputation and political relations aspect of it as well. And so respecting the confidentiality of the employees involved, the reporters involved, and the decision makers involved is very important on all of those steps.
I've noticed with off-duty conduct, especially when we're dealing with social media content or something else that employees are using on their personal time, a lot of times employees will say, well, I have the right to free speech, or I have the right to free expression. And that's true to an extent, but the First Amendment really only protects the federal government from intruding on our right to free speech. And that was expanded by the 14th Amendment to intrusions by the state and local governments. But for private employers, there are fewer concerns there. The First and 14th Amendment don't really apply to private employers. Now, you'll notice that I said that there are fewer concerns and not no concerns, because there are, like Anthony said, some state laws that apply. There are some states that have expanded those free speech rights to private employment and have restricted the ability of employers to take action. Other states protect political speech, which Hillary's going to talk to us a little bit about. And still other states prohibit employers from taking action based on any legal off-duty conduct of an employee. And so that's why that legal review that Anthony talked about was important. And that's also important when you're looking at policies that might implicate those sorts of state laws. And the policies that normally come into play when we're talking about freedom of speech or free expression are your dress code policies. What can you wear? What can you have on your t-shirt? These days, what can you have on your mask? It seems like the popular thing to do. You want those policies to be neutral, and you want them to apply across the board. You don't want them to prohibit activity of one group without prohibiting similar activity of another group. You want to look at your solicitation policies. When and where can employees solicit other employees? Take a look at your social media policies and see if they apply to conduct that might occur outside of your workplace. Any threatening, discriminatory, harassing, abusive, or bullying behavior, whether to third parties or employees, could be prohibited. And then finally, those workplace bullying and violence and threatening behavior policies. Take a look at those and shore those up. When you're enforcing those policies, make sure that you are enforcing them consistently. In other words, if someone wants to wear a mask for the Black Lives Matter movement, for example, you wouldn't want to prohibit that, but allow employees to wear masks celebrating Pride Month. You want to make sure that there's consistent application. And then always consider that that activity that is protected, concerted activity, complaining about terms and conditions of employment. And then finally, consider the press and the media attention that comes from these sorts of things. Neutral policies are great, but sometimes there are reasons, especially in the retail industry or service industry, where you might decide to go ahead and put something together to help employees express their beliefs in one way or the other. So I think that's all that Anthony and I have. We will toss it back to John.
Thanks, guys. My name is John Anderson. I'm an attorney with Husch Blackwell in the Madison, Wisconsin office. I'll be reporting on some NLRB cases today that I have selected. The cases evince a trend, a very positive trend, of returning to past precedent. As a practitioner, I find this to be very helpful. It offers stability, predictability, and common sense. Employers were quite disappointed in 2015 when the National Labor Relations Board issued the Banner Estrella Medical Center decision. Under Banner, confidentiality rules and investigations were challenged. The normal advice that we provide to employers is during the course of an investigation, let's try to maintain confidentiality so that we can preserve the integrity of the investigation. Banner required an employer to make a case-by-case determination of whether confidentiality can be required in a specific investigation. And the board's prior test failed to consider the importance of the employer's confidentiality assurances to both employers and employees during an ongoing investigation. So these rules that employers wanted to maintain and had maintained for many years were designed to protect the integrity of the investigation. Board law change is slow, but when a case came through the regions, the board picked it up and used it to restore common sense in regard to employer investigations. Under the Apogee Retail LLC decision, the new rule applied the facially neutral workplace rules test established in the Boeing Company decision from 2017. And now investigative confidentiality rules limited to the duration of the investigation are generally going to be found to be lawful. Common sense prevails. As a practitioner in labor law, we were frustrated by the board's decision in Purple Communications. Under Purple Communications, employees were presumptively able to use employer email systems to communicate with one another for organizing purposes, non-work purposes, Section 7 activities. This access was designed by the prior board to help organized labor access workplaces and to make responding to organizing efforts more difficult. Employer systems were used by employees for non-work purposes. The board's general counsel hinted at this area of the law as something that he would focus on and try to find a case to bring to the board when he issued his general counsel memo in late 2017. So we were delighted when Caesars Entertainment came forward and the board decided that an employer can indeed regulate, restrict, or even outright ban employee use of employer-owned tech systems for non-work purposes as long as they don't discriminate. The exception is narrow, and that is the employees may use the employer email for Section 7 activities when they are the only reasonable means for employees to communicate with one another. And that's a pretty high standard. The NLRB in 2015 changed course when it overruled a 50-year-old precedent concerning dues checkoff upon expiration of a collective bargaining agreement. The board decided that dues checkoff provisions as mandatory subjects of bargaining need to be maintained as part of the status quo when the collective bargaining agreement expires. Not only was this action against precedent, but it certainly impacted the balance of power at the collective bargaining table by removing an incentive to settle. You're sitting at the bargaining table with the union, the contract's going to expire at midnight, and you're making proposals back and forth. The union has to be worried about the fact that this contract's going to expire, and under prior law, the collective bargaining obligation to collect dues under that contract would also expire. In the Valley Hospital case, the board recognized that dues checkoff is a mandatory subject of bargaining, which of course it is, but it also said that it's dependent upon the existence of a valid labor contract. This was also one of the many areas that were highlighted by the board's general counsel in 2017. So under the new precedent of Valley Hospital, employers can stop dues deduction upon expiration of the collective bargaining agreement. Another positive trend towards stability, predictability, and real-world common sense was the 800 River Road decision. A union is elected, the NLRB certifies the results of the election, and collective bargaining begins. But life and business operations also continue while you're negotiating that first contract. And that may include the need to discipline an employee for performance or a work rule violation. The Obama board imposed the obligation on employers to bargain over significant discipline before that initial collective bargaining agreement was inked. That was in the Total Security case decided in 2016. That interfered with collective bargaining and it slowed down the existing processes and was not well received by employers. The 800 River Road case restores the law as it existed. You can now apply existing disciplinary policies in accordance with past practice while you're negotiating that first contract. Again, this was part of the roadmap set forth by the NLRB's general counsel and the types of cases it wanted to bring to the board. Lastly, I put this decision in because it's an election year. Board elections provide two choices to employees, either voting for the union or voting against the union. So an employee in a union election takes a ballot and goes into the private ballot area in the voting booth and marks the ballot either for or against. Elections are often decided by a few ballots, and we want to count them all because a discarded ballot makes it easier for the union to win the required 50%. The NLRB has said they're getting out of the business of determining intent when a ballot is marked in more than one box. So if you go into the voting box and you vote for the union, and then you said, oh, I changed my mind, you erase it, and then you mark against the union, there's a mark in both boxes perhaps. So the board has said, we're not going to decide that anymore. Bright line rule has been adopted, and that is that marking in more than one box, the ballot is void. They've also adopted new procedures designed to put people on notice. If you screw up a ballot, please request a new one, because if there's a dual mark ballot, it's not going to be counted. Now I'd like to turn this over to Kevin, who's going to talk about an issue that every employer, not just union employers, face, and that's social media under the National Labor Relations Act.
Thanks, John. I'm Kevin Karanka with the firm's Austin, Texas office, and like John mentioned, I'm going to talk a little bit today about the NLRA and social media in the workplace. So the growth of social media platforms continues to impact employers in a variety of different ways. With the pandemic, employees obviously are working in different ways. They are communicating in different ways, and you fold that in against the backdrop of this being an election year and some of the social issues that our country is facing. And you find employees more and more often going onto social media to vent or express their opinions about issues in the workplace or current events, or perhaps often the intersection between the two. So generally, employers can establish guidelines and workplace rules that govern employees' social media usage. But where issues often arise is where a workplace rule either inadvertently or inappropriately interferes with an employee's right to engage in Section 7 protected activity. So that is engaging in concerted activity for the purpose of collective bargaining or for other mutual aid and protection. We're not talking about issues where employees go onto social media and complain about their supervisor. This is more generally issues where employees are expressing group concerns or toward a group about the terms and conditions of their employment. And importantly, this applies to both unionized and non-unionized settings. So it doesn't matter whether you have a CBA with your employees or not, every employee has these Section 7 rights that we're going to talk about. The board is looking at social media policies from the perspective of whether or not they would reasonably tend to chill employees in the exercise of those Section 7 rights. There's been a lot of back and forth on this issue over the years, and it's hard to know where the line is today. A rule that may seem neutral on its face may in fact impact an employee's or employees plural Section 7 rights. So a few years back, the board released its Boeing decision, which many of you are probably familiar with. In that decision, the board considered the legality of Boeing's workplace policy that restricted the use of camera-enabled devices like smartphones. Essentially, the policy said that if an employee was to bring a smartphone into the workplace, they had to have a legitimate reason for doing it, and they had to have written permission to do so. But the policy didn't otherwise, attempt to restrict the general terms and conditions of employment. The board came out and said the way that we look at these situations, there are three categories of rules: those that are lawful, those that are unlawful, and then those like this that are more in the middle, that they warrant individual scrutiny. And so what the board does in order to evaluate those sort of facially neutral handbook policies is to look at the potential impact on employee rights and then the employer's justification for the rule, and tries to balance the two. And in Boeing, the board found that the policy was lawful because Boeing had a legitimate reason to keep the cameras out of the workplace. They work on a bunch of sensitive projects, and they didn't want employees to have the potential to record and divulge that information. The board did find that it did slightly impact the employee's Section 7 rights, but that impact was comparatively slight, and so the board sided with Boeing on the issue. More recently, the NLRB's General Counsel Office has come out with several advice memos that concern social media policies. Generally, that first memorandum, the bullet point, says that employers can maintain social media policies that require just sort of basic standards of civility or human decency. Be kind to each other. That sort of policy doesn't restrict Section 7 rights unlawfully. Second, it's lawful to ask employees to identify themselves as employees and to state that their opinions are their own opinions. They're not the company's opinions. But the third memo that came out recently, broad policies that prohibit employees altogether from criticizing the employer or from saying you have to post complete, accurate information on social media about the company. The board found that those sort of policies can be unlawful because they could tend to chill employees' rights. Employees may not go onto social media if they think that the company is going to say, well, what you posted wasn't completely accurate, and try to discipline them for it. So the board said, looking at that balancing test, those sort of rules can be unlawful. And here recently, in the last month and a half or so, the board has released 3 new decisions that we'll talk about just briefly about social media in the workplace. First, the Bemis case in August. The rule prohibited employees from first disclosing proprietary information about the employer on social media, but it also required the employees to be both respectful and professional when they're using social media tools. And the justification was the employer has an interest in safeguarding its reputation. The board found in Bemis that when you read the policy as a whole, employees would understand that the rule was made to safeguard the employer's reputation and to promote a healthy work environment, not to chill an employee's Section 7 rights. A week or two prior, the board came out with the Motor City Pond decision. That was a rule that is essentially a non-disparagement provision that said employees should not say anything negative or disparaging about the company to its customers or third parties on social media. And the board found that employers, that was a lawful rule because employers have a legitimate expectation of loyalty, and that the rule was reasonably drafted to warn employees that similarly disparaging statements about it to customers or to the general public wouldn't be tolerated. The board found that that was lawful. And you contrast that with the Union Tank Car Company case that came out just a week prior. Again, as a non-disparagement rule, don't say anything that's intended to injure the reputation of the company to customers or to employees. And the board's decision in Union Tank Car really focused on that prohibition about communications amongst coworkers about things that may injure the company. And the board found that there's no justification for the rule because it specifically impaired employees' Section 7 rights. They should be able to talk to one another about the terms and conditions of their work, whether it's negative or not about the company. So that's all I've got in terms of social media and the NLRA, but I'm going to hand things off next to my partner, Hillary Klein, who's going to discuss election leave issues.
Thanks, Kevin. I'm Hillary Klein. Good morning or good afternoon, depending on where you are. You might think I'm a little casually dressed for a seminar like this, but I am coming to you from Tennessee, and I'm going to be talking about voting, and so I just couldn't resist the opportunity to wear my Vote Y'all shirt. So let's dive in here. Every year at election time, we get sort of a handful of standard questions from our clients, and they fall into these buckets that are up here on the screen. Are we required to give employees time off to vote? Do we have to pay them if we do have to give them time off? What sort of notice do employees have to give us about their need for time off to vote? And do we need to do anything in terms of providing notice to employees about their rights related to voting leave? So let's start with, is voting leave even required? For private employers, there is no federal mandate. However, most states, or I should say many states, probably about half of them, have some sort of voting leave law. And what that looks like varies from state to state. If there is sort of a pattern to it, I would say it is this. If employees don't have sufficient time, reasonable time before or after their shift, during which the polls are open to go vote, then employees have to provide leave. So that's a generalization, but if you kind of look at all the laws that are out there and generalize them, that's sort of the summary. And there are nuances from state to state. Some will define what's considered reasonable time to vote outside of polling hours. Some will say they have to have 2 hours before or after their shift. Some will say they have to have 3 hours before or after their shift. Some will just say a reasonable amount of time. And in other states, an employer simply has to provide a certain amount of time to employees to vote, whether or not they have time before or after their shift to do it on their own. Another question related to leave in the voting season that sometimes comes up is, what if somebody wants to serve as an election official? Do we have to give them time off for that? And you'll have to, like with other voting leave laws or issues, you'll have to look at the laws in the state where the employee has made the request. For the most part, that is not covered by the voting leave laws, but there are some states that require that. Ohio is an example. You'll also want to look at your local ordinances for all of these voting issues. Some cities, some counties will have their own local laws regarding leave. What about pay? So if you have to give employees time off to vote, do you have to pay them? And again, that's going to be governed by those state and local statutes and ordinances. So you'll have to look at those. Some do require pay and some do not. One thing that I do want to highlight for you, with your exempt employees, make sure that you are not deducting from their pay when they take time off to go vote. So they take a few hours in the morning or a few hours in the afternoon to go vote. They should still be paid for the entirety of that day. Making deductions, of course, could jeopardize the exemption under the Fair Labor Standards Act. So just be careful there. Do employees have to give you notice if they want to take time off to vote? Well, again, depends on the state law, and that's going to vary, or the local law, that's going to vary from law to law. For example, here in Tennessee where I am, employees just have to notify their employer by noon the day before of their need to be off to vote. I would say most states that have notice requirements don't require more than about a day. So yes, there are some notice requirements, but they're pretty short in most locations. So should we publish details about voting leave rights of employees? A handful of states do require a posting of the voting leave rights, but even in the states where that's not required, which I would say is the greater majority, it still may be helpful to share that information with employees in advance. Among other things, it can help with planning, because if you give employees sort of a heads up about what's allowed, then they are more likely to give you an idea that they may need to be off that day for a couple of hours to vote, or they may want to come in a little bit late, or whatever the case may be, and it just may make the planning a little bit easier for that day. So I think a big question that many companies are facing right now is, even if we aren't required to offer voting leave, should we offer it? Or even if we are required, should we offer something above and beyond that which is required? And there is certainly some social pressure to do that. You all have probably seen some stuff in the media about this. Just by way of example, a few weeks ago, comedian Sarah Silverman tweeted and tagged a number of large companies, and her tweet said this: "Who's going to step up and make Election Day a day off instead of a classic farce?" Coca-Cola was one of the companies that she tagged in that tweet, and Coca-Cola pretty immediately responded and said that they were going to give employees the day off, Election Day off, and also said that they were joining the Time to Vote coalition. Some of you may be familiar with the Time to Vote coalition, but it is a self-described, nonpartisan effort of companies who, quote, want to contribute to the cultural shift needed to increase voter participation in our country's elections. So it's a group of corporations, CEOs have come together and said, we really want to see what we can do to make some changes and increase voter participation. Some companies have made Election Day a paid holiday for employees, some major retailers, I think Starbucks may be one of them. And then other companies are making some deviations that are likely only for this election season, but some deviations to help ensure that voter turnout is good during this COVID season. For example, even though not required, some employers are allowing employees to take leave for early in-person voting. So the bottom line here is that you need to review your state and local voting leave laws, do that well in advance so that you're prepared for Election Day. And then I would encourage you all to consider some of these sort of social pressures and what impact they can have on both the morale in the workplace and on perception of your company. So with that, I would say vote y'all, and I'll turn it back over to Julianne and AJ.
Thank you very much, Hillary. That is the last substantive presentation for the day, and we understand from our end that there have been some additional delays there as the software worked through our numerous attendees, and we will obviously be working on to ensure that our future presentations are as glitchy as can be. And thank you for around. We've got a couple of poll questions, a couple of reminders, and then we will wrap up.
Our second question. Will your organization allow employees to continue teleworking after state and local pandemic restrictions are lifted? Answers are yes, we are already planning to allow telework, considering but have not yet made a final determination. Maybe leadership has not yet discussed. No, we are not planning to allow telework. We don't have telework employees. So while you're giving your answers to this poll question, the program has been approved for HR and legal education hours. And to report your hours, click on this icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing.
So let's see what those poll results were.
And it looks like most of you are either considering planning or planning already to allow telework after the stay-home orders are lifted.
Okay, so now we will move to our last poll question for the day. And this relates to whether or not your organization has already implemented in 2020 or is planning to implement it in 2020 or consider a new plan for diversity and income. And your options are yes, we're already in-house team, consultant, yes, but we're working on our plan still, or no, we are not planning to implement any sort of new diversity and inclusion program. And again, while you answer, a quick reminder that please take the time to complete the short survey that's at the bottom of your screen. It does provide us with a lot of useful information that helps us determine how in future programs to make sure we provide you what you and your businesses need. So now we'll take a look at our results for that final poll question. And it looks like the majority of you are in one of two camps. You've either already started implementing in-house, or you have determined that you already have the programs that your employer for your organization are still working on a plan. Well, we certainly appreciate you taking the time to be with us today for our national program. We hope to see you again virtually or in person as soon as we're able. And thank you
for joining us.